With profound respect to the Honorable Court, my name is Shegun Adedoyin. Adedoyi for the claimant. And with me is yes, my lord, Adedoyi for the claimant. And for the claimant. With me is Ejimofo.
Yes. Yes. Yes.
The matter is adjourned for cross-examination of the claimant.
You are witness ready for cross-examination.
Yes, my lord.
All right. Yes.
Good morning, Ms. Kemi. Just to remind you that you are still under oath.
Yes.
I need you to respond to that.
Yes, I am.
Okay.
Yes, I am.
Witness is ready to go.
Yes, the defense counsel will be asking you questions and you answer it, and then the court will record you down. Any question you do not understand, you ask it so that I clear it from you. You understand?
Yes, all right.
Yes.
Yes, I do.
The counsel will approve it.
Yes.
Yes. My lord. On the 20th day of January 2025, you testified the chief before this court. That's correct.
Sir, I didn't hear you.
Sir, I didn't hear you. I can hear you.
And if I want to listen, I can talk now. Then okay, Miss Ken, can you hear me now?
Yes, I can.
Okay. I said on the 31st day of January, 30th day of January 2025, you gave your evidence before this court. That's correct.
Yes, that's correct.
What's your answer, please?
That is correct.
What's your answer, please?
That is correct.
Now, allegation give evidence to shoot.
Yes.
Okay. On that same day, you identified your signature
Yes, I did.
on your written deposition and adopted same. That's correct.
Yes, that is correct.
Okay.
Yes.
That's my lord. She has answered?
Yes.
Okay. She said yes. Okay, very well. In your document number 1, on the list of your documents, appointment letter or offer of employment, which is Exhibit C1 before this court. Exhibit C1, my lord.
Yes.
Okay. You appended your signature on the second page of Exhibit C1. That's correct.
Yes, that is correct.
You also appended your signature at page 5 of the same document. Page 5 of Exhibit C1. That's correct too?
Yes, that is correct.
Okay.
Yes.
On your witness statement on oath, that is your written deposition which you adopted on the said 30th January 2025. Yes. You signed that your written deposition. That's your signature.
Yes, that's
No, my lord. The other one is Exhibit C1. Her signatures in Exhibit C1. This one is her signature on the written deposition. She's responded in positive, sir. Yes, sir. So also on the verifying affidavit, yes, the verifying affidavit in the originating processor. You also sign same.
Yes, I did.
Let's copy this. In the computer certificate in compliance with section 84 of Evidence Act, which you tendered, that is Exhibit C8, my lord. Exhibit C8.
Yes.
You also sign same.
Yes, I did.
That is the verifying affidavit. That's the last document before the exhibits. No, third to the last after reading the position. Okay.
Yes.
Yes, sir. I know that we want to tender a document through her, which she signed as well. There's a document she signed, the defendant's staff policy manual. It's not front-loaded. Okay, you remember Substrata Oil and Gas Staff Policy Manual, which you signed upon your employment.
Remember what?
The defendant, that is Substrata Oil and Gas Staff Policy Manual, which is signed with the thereof. Please, can you show her?
What is our response?
You remember the document?
No, I
What
don't.
is the title of the document?
You can't remember the document?
No, I don't.
Put it in such a way that she will see it,
Okay.
as well as show her the signature.
Do you remember signing this document? Employee acknowledgement form.
This was when I was employed as an NYSC intern, not when I was given employment. My NYSC period ran from 2019 till March 2020. So I stopped working in Substrata at March 2020 as an NYSC.
No, I'm just showing you the document bearing your signature for identification. There it is written employees. Hold on. There it is written where you signed employee's name, Pedro Mary Oluwakemi. Employee signature you signed, dated 31st of May 2019. Do you remember the document?
Yes, I remember this document.
Very well. My lord, we seek to tender this.
My employment was given mandatory NYSC.
Just the page getting her signature, page 7, sir.
I remember signing the document. She says she remembers signing the document at the okay.
She signed read the document. She signed as a
The document as a copper, as a Nigerian copper, not as a full-time employee.
When Kemi, when did you sign the document, the witness?
As a copper, as an NYSC member in 2019.
Okay, as an NYSC member, not an employee.
Not an employee.
All right.
My lord, she was an employee then, but after the during the NYC program, was left. After a while, she came back to the company to take.
But the bottom line is the signature.
And page 56 of the document. But bottom line is the signature, sir.
Council. Page what? Page
56, page 7 and page 56 of the document, sir.
My lord, with due respect, sir, I not sure that this document was front-loaded.
No, it's not. He has stated that the document is not front-loaded.
My lord, then if it was not front-loaded, if it was not reflected in the statement of claim, I don't know how my learned friend can be tendering this document.
He is cross-examining the witness on the signature.
Oh, my lord, I thought he said he would want to tender. That's what he said.
My lord, documents.
Have you applied to tender it in evidence?
Yes, my lord. I've applied to tender it, sir. Documents are admissible during cross-examination of a witness. Page 7, the relevant pages.
Page 7 and page 56.
Yes, my lord. I said the relevant document. Pages 7 and 56. There's no signature on page 56. Yes.
My lord, this would be an ambush, my lord, if my learned friend has made no reference to this document in his statement of defense.
Then you address the court at the address stage.
As a copy.
Yes. Yes. He applied to tender in evidence. Are you opposing or?
I am not the lead counsel on virtual and made their comments.
All right.
Which my lord directed, he should address you during.
Okay. Layman's counsel. We intend
7 and 56.
The admissibility.
My lord, the relevant pages, as I said earlier, are pages 7
and 56.
And 56.
Yes.
And that is comparative. This panel of the defendant to bring the court to tender relevant pages and retrieve the entire booklet. It's a confidential document of the company.
Objection of the honor.
We want it to be on record that we objected to the tendering of this
it's
document.
recorded down.
Matter for hearing. It's your matter for hearing. Yes. This one will last. Actually, maybe we should have one.
Yes, objection of the learned counsel for the claimant is hereby noted, and counsel is ordered to argue his objection at the stage of final address. Meanwhile, the document is admitted in evidence, is admitted and marked as Exhibit D1. Yes, at the stage of final address, you raise and argue your objection.
As copies.
But we normally substitute the 2 pages with the photocopy.
No, but this is a document. If you bring the 2 pages, will they serve any meaning?
So the document is properly headed. The documents are
Let me see. Let me see the pages.
A counsel cannot isolate a whole document. A document is a document. You tender it or you don't tender it. You don't remove extracts. The court needs sufficient material to be able to reach a decision.
My lord, is a confidential document, policy document of the company. If my lord looks at the relevant pages.
But this is like this second page 56. It's a continuation of a document.
Yes, but those are the 2 relevant.
It cannot stand on its own. If this one can stand on its own, employee acknowledgement form. But this one cannot stand on its own.
Okay, we will drop page 56, sir. We will drop page 56.
So you want to withdraw page 56? What was the application first? You want to substitute the original with a copy?
Page 7.
Page 7.
Same.
application for substitution is hereby granted, and page 50, substitution of page 7. Page 7 of the document is hereby granted, and page 56 of the document earlier referred to is hereby struck out.
I've copied it.
So, employee acknowledgement form is marked as exhibit. Registrar. Yes. D1. Yes.
Okay.
Yes, Council.
Yes, witness, those signatures as mentioned in appointment letter exhibit C1 in your witness statement on oath, verifying affidavit, the originating process,
I'm coming.
certificate,
Those signatures
yes, in exhibit
exhibit C1.
That is appointment
Yes.
letter or offer of employment.
Yes.
She tendered her signature in the written statement.
On the yes.
Affidavit,
Verifying affidavit.
Okay.
Is it verifying affidavit?
Verifying affidavit. Yes, accompanying the originating process.
Yes.
Her signature on the computer certificate in compliance with section 84 of evidence, and that is exhibit D8.
Yes.
And her signature on exhibit D1. These signatures are your correct signatures.
Yes, they're my signature.
What do you say?
Yes, they are my correct signature.
Ask her, please. She said, yes, my lord. In those signatures, which are all your correct signatures, there is one noticeable and conspicuous feature on them, namely initial KP. That's correct.
Yeah.
Okay. In those have correct signatures. There are, feature, noticeable, very conspicuous, my lord. Initial KP, and she answered yes. KP, yes, sir. K, Kemi, P, Pedro. As copies. Yes, witness. All your signatures must appear like that. That's correct.
Yes.
In other words, you have only one signature.
I didn't get you, sorry.
In other words, you have only one signature, not multiple, just one signature.
Sometimes if I'm signing when I'm in a rush, I just sign the other initials apart from the KP. But for official documents, bank documents, and employment letter, the KP is always.
I can't hear you very well. My Lord, I'm not hearing her very well. Yeah, if you can be more audible.
Please answer. Sign again.
Hello?
Yes.
I said I don't have one particular signature because sometimes I may be in a rush. So I have like a couple of signatures. And also my initial.
My Lord, signature.
My initials. Yes, counsel.
Signature, or is maybe at the time of address. Signature is a monogram. It's particular to a particular person.
Counsel, that one is for address.
Yes, I said it. I pointed it out.
You ask the question.
Since you said that all your signatures must appear like the signatures in Exhibit C1, your witness statement on oath, verifying affidavit, computer certificate, Exhibit D1. Any signature against your name that does not appear like the signatures in the above these documents is not your signature.
Sorry, I didn't get your question. Can you rephrase?
You have identified 5 documents bearing your signature as your correct signature. And
Yes.
I'm asking you, against your name that does not appear like the signature, does not appear like the signature in your signature. That's correct.
Said like you have one signature. Are you saying that you have
My Lord, you know, one thing with this virtual here.
Yes. Counsel, are you telling the witness?
Telling her what to say.
Counsel.
My Lord, I can hear the counsel.
We are hearing you now.
I can hear the counsel, but
what are you telling the witness? Allow the witness to answer the question.
Yes, that's what I'm doing.
I was repeating the question. I didn't hear him.
My Lord, if the counsel,
what is there that he's going to repeat the question?
There was an
He
echo.
referred you to 6 documents, and he said the signature on them are your signatures. You say yes. The question is, if there is any other signature apart from the one on these 6 documents, it's not your signature. What is your answer?
I explained earlier that for official documents, I try to stick to one that has KP. But for unofficial documents, depending on how much, it not have the exact same, but it would be similar.
For the unofficial document,
I said that sometimes for unofficial documents, it may not be 100%
KP. But
His lawyer that is, I'm hearing his
unofficial
lawyer more than
document.
witness.
Yes, what did you say for the
Sorry, I can't hear. I can't hear anything. Muted.
Okay. Yes. It said me not to be 100% exactly as what?
As the ones like official documents. Sometimes when I even go to the bank, I am asked to resign because it is not the same thing that is on their system.
Okay. All right. Yes, counsel.
In other words, we have multiple signatures.
In other words,
In other words, you have multiple signatures.
yes. Not exactly multiple, but it is not always 100% same thing. That's what I'm trying to explain.
Which one do you want court to record? Is it yes or not exactly?
Not exactly.
All right. Yes, counsel. Registrar, what is the time?
Furthermore, your signatures in official documents are the same.
Yes, they are.
Okay.
Yes.
Okay. You know your handwriting when you see it.
I don't have one handwriting.
You don't have one handwriting. You have as many as how many?
I don't know. My handwriting changed.
Pardon?
Said I don't know. My handwriting changes depending on the type of biro I'm using, the kind of ink, if it's a ball pen or an executive pen. There's no particular handwriting.
Yes.
You do not have a particular handwriting.
No, I don't.
There are many, right?
Sorry, what?
You have many handwritings.
Yes.
Or you can identify those are many handwritings anytime you see them.
Possibly, yeah.
You can identify those many handwritings anytime you see them.
Yes.
Yes.
Okay. In your letter of 19th May 2023,
I can't hear you, sorry.
in your solicitor's letter of 19th May 2023, that is Exhibit C3, my lord.
Yes.
You claim the sum of 540,000 naira
Yes, I did.
as the amount due to you.
Yes, I did.
Yes.
In your relief one, this suit, you are claiming the sum of 517,799 naira 97 kobo.
Please, can you repeat it?
In relief one, in this your suit, relief one, you are claiming the sum of 517,799 naira 97 kobo. That's correct.
Yes, it is.
Yes.
In paragraph of your witness statement on oath, paragraph 14 of your written deposition,
Yes.
you claimed that the sum of 421,458 naira 90 kobo was the amount due to you.
That was the amount
as unpaid.
That was the amount the accountant put in the breakdown of payment.
Allow him to finish the question. Finish the question first.
Okay.
You say was the amount due to her or what?
You in that paragraph 14, you claim that some
Yes, what is your answer?
Naira 90 kobo was the
Paragraph 14. Yes, witness, we are hearing you.
I said that was the amount that was broken down by the accountant of substrata as at when
accountant of
substrata oil and gas.
All right.
I'm not asking you to break down. Read the paragraph very well. I further state that the defendant's accountant, after reconciling the account, came up with the sum of 421,458 naira 90 kobo
Yes.
Okay. She said yes, sir. You went further to state that that amount was arrived at after reconciling the account. Paragraph
Which
14,
paragraph?
the same paragraph 14.
Okay.
Paragraph 14.
Yes.
You went further to say that that amount was arrived at after.
Yes, witness.
Sorry, I didn't get him.
Are you reading from paragraph 14?
Yes, my lord.
Yes, counsel. Tell your counsel to show you paragraph 14 of the written deposition.
Okay.
Yeah. You have it.
My lord, I don't know if I can read it for her just to confirm for follow-up question.
They have it there with them. Oh, you listen to the counsel. Let him read it for you.
Okay. I have it here.
All right.
Okay. Confirm what you stated there.
The defense.
This is the position.
No.
Position. Tell him to read whatever.
Can you read what you have there?
Pardon?
Please, can you read what you
Paragraph
have there?
14. Is it not the same with paragraph 14 of what you file in court? Counsel, read it.
I'm reading your statement, paragraph 14 of your
Written deposition.
Written deposition. I further state that the defendant's accountant, after reconciling the account, came up with a sum of 451,458 naira 90 kobo, as against the sum of 460,426 naira 64 kobo to be paid to me on the basis that I was not regular in attendance to work throughout the 8 months and cannot be paid full salary for those months. You went on to say, I plead and shall rely on the snapshots of defendant's accountant's handwritten quotation and total amount to be paid. That is your statement.
Yes, what is your question? Is she to confirm?
Okay. The so-called snapshot exhibit C6, my lord, was your own calculation and not that of the accountant of the defendant.
Yes, witness. Have you heard him?
Yes, that is very wrong. The day I was giving my redundancy letter, in the letter, it stated that I should meet the accountant to reconcile the account and also meet the admin to tender any company documents or any company property that I have. I went to meet the accountant and then she reconciled it and gave me the paper. And I also submitted the documents to the admin. After which I went to meet the MD, Dr. Kayode Thomas, and he confirmed that he
Hold
has.
on, witness. That all these things you are saying are contained in your witness statement on oath.
What he is asking you is that snapshot you pleaded and relied upon.
I'm not that of the defendant.
He says it's your calculation, not that of the defendant.
No, it is not my calculation. It is the
All right.
accountant defendant's calculation.
Okay.
Yes.
According to you,
Registrar, are you timing him? For cross-examination, you have 40 minutes.
on the hold, for
Is there, check order 40, rule 19, sub rule 2.
for the whole process.
For the entire cross-examination, you already have the deposition with you. So you are expected to outline the questions and come and ask them.
That's exactly what I did, sir.
Yes.
That's exactly what I did. And I wasn't informed.
So the rule gave the judge a power to control the duration of cross-examination.
And this virtual, assuming...
Nevertheless, it will be taken into consideration if there is network issue. But you have been asking questions. And he has been positively answering your question.
My lord,
we never spend 2 or 3 minutes without having issue of network. She will only ask you to repeat the question, which is, I'm sure, in seconds, you repeat your questions.
My lord, because it is virtual, even though I know that the rule applies to virtual as well, I may not be able to finish within 40 minutes.
We cannot add any time. You either finish it or we close you.
Okay. In that your calculation, that's correct.
That is not my calculation.
But you claim that you were absent from work for only 8 days.
I didn't get you, sorry.
You claim that you were absent from work for only 8 days.
That you were absent?
Yes.
Okay. In other words, you did not attend work at all. That's correct, right?
Yes, there were days because I was being owed salary. I need money to be able to transport myself to work. So it was towards 7 months that I started taking some days off because I couldn't get someone to borrow me.
You have answered that leg of the question. You have answered me.
So she was absent for only 8 days.
She claimed that she was absent for work for only 8 days as against the calculation of the defendant.
Okay. Yes.
In the defendant's letter of 31 May 2023 written to your solicitor, which you exhibited.
Exhibit what?
My Lord.
Continue.
In that letter.
Yes.
Of 31st May, in reply to your solicitor's letter of 19th May 2023, the letter enlisted the number of days you attended work in each of the months between January 2023 and September 2023. That's correct.
Yes, the letter had that, but those days were wrong, which I communicated to him.
Yes.
It was from those number of days as enlisted by the defendant that you attended work, and the days you did not attend work, and deductions made thereafter, that the amount of money due to you for the period in question amounted to 231,092 naira 98 kobo.
Like I stated initially, those days are wrong because I was attending, apart from the days that the accountant said I didn't attend, which was on her list. She had an attendance sheet on her Excel folder, which she used to calculate the money. So she told me the days I wasn't absent. And also in the letter I signed, the mind that at that point. But now coming to say I only attended.
She's like giving a story. I expected you to.
Okay. You are aware of the defendant's policy of no work, no pay. You are aware of that?
Let me take this, your last question properly. You say it was from those days.
It is from that
they attended and those that she did not attend.
Yeah. Those attended work and those did not attend work.
Yes.
Were deducted, and the amount was arrived at 231,092 naira 98 kobo, which the defendant had paid to this court, sir, as the amount due to the claimant.
Yes, what is your answer?
I said those dates are inaccurate. I went to office practically every other month except the 7th and 8th month when I couldn't afford to be going to the office every day anymore.
So in essence, you are saying the calculations were wrong. Okay.
The defendant also sent you a mail informing you of that sum,
yes,
231,098 naira 98 will be the amount due to you, and requested for your account details for payment, and you refused. That's correct.
Sorry, I didn't get your question.
The defendant sent you a mail on the 3rd day of March 2023 requesting you to confirm and send account details for payment of that sum, and you refused.
I did not refuse. I only sent a mail back to them saying that those were not the days I was in the office. And this was after hounding him for calls, and it wasn't in March, it was in May. He sent it in May.
The question is that the defendant sent you an email on the 3rd day of May 2023.
He sent
asking
an email
you to confirm and send account details for payment of that sum, 231,098 naira 98 kobo, 92 naira 98 kobo, and you refused.
He did not ask to send an account details. He told me to sign against it, which I refused because it was wrong. He did not ask for account details.
You refused. He said sign
and it was the wrong
defendant to process your payment. You refused.
I can't
My lord, sir, counsel should allow the witness to explain herself. He's virtually.
What is your answer, the witness? Say he did not ask you to send your account or what?
He didn't ask to send my account details. He sent a report saying this were the days I worked.
He said confirm for the defendant to process your payment.
Counsel should allow this witness to talk, sir, with all due respect, sir.
I'm hearing you, witness. Tell me your own answer.
Yes, he sent an email stating that he has
The
Counsel,
question is that you
allow her to answer.
refuse.
You said he sent an email.
Yes, he sent an email this few days. The doctor that I came to work, I told him I couldn't sign it because they were wrong. That I came to work more than those days. Aside the physical attendance we had, there was an e-card we used to use to clock in. So that e-card should also be able to show that I was in office all the days.
Counsel, witness, we are not asking you for story. You had his question, confirm whether it is true or not.
I said he sent the email, yes, but he asked me to sign against the wrong date, which I couldn't provide my signature.
Okay, you refused to sign. Okay.
He asked to send an account number also. He did not ask to send an account number.
All right.
I ask you.
Yes.
You are aware of the policy of no work, no pay. You are aware of that?
No, I'm not.
You are not aware of the defendant's policy of no work, no pay.
I'm not.
Okay.
Yes.
Can you be paid for days you didn't attend work, you didn't work?
Can I what?
Can you be paid for any day you didn't attend work and without good reason?
You said, can I what, please?
Can you be paid for days that you didn't attend work?
The reason I didn't attend work.
Can you be paid? So can I help, sir?
Not really. Can you be paid any day you did not attend work?
Can you be paid for days that you did not attend work?
If I am doing my work from home, I don't see why. I mean, there's remote work these days. There are days people work from home. So as long as my job is not being affected.
Answer my question.
Witness, answer the question.
Yes, I can, because I was working from home.
Be paid for. Okay.
I did not attend work because I wasn't working at home.
That is not my question.
Counsel, continue.
Okay.
Registrar,
my Lord,
allow him. You have seen we have difficulties in answering the question.
Witness, habit of procuring some other staff to sign the attendance register for you against the company policy.
I never procured anybody to sign. I never procured anybody to sign for me. Any day that my name appeared in the signature, in the register, I was the one that signed, and I was in the office on that day. And even when I was being owed for 5, 6, 7 months, I was still coming to the office.
Yes, continue.
I put it to you that Exhibit C was your own calculation for you and by yourself.
No, it wasn't.
Exhibit C what? Okay. It's our own calculation. Yes, witness, what is your answer?
That is a wrong and false accusation. They were not my own calculation. They were calculated by the accountant or social.
Yes.
That reconciliation was not done in one day.
Sorry, I didn't get it.
Yes. Ask the
That
question.
calculation, that reconciliation was not done in one day.
Please, can you unmute your mic? I can't hear you clearly.
He said that reconciliation was not done on one day.
No, it was done in the presence of the accountant in a few minutes even. She just had to pull up an Excel sheet from her computer. She wrote down the amount, she calculated the total. That was it.
So all was done in one day.
Yes, it was done on the day I was giving my letter of redundant.
Okay. On that same day, when showed you the correct amount, that is 221,098 naira 98 kobo. After deducting number of days you paid to attend work, you left with anger. Try to deal with the defendant. That's correct.
No, I never left. In fact, when I was leaving, when the accountant gave me the letter, the calculation, I came back to meet the defendant, that's Dr. Kayode Thomo, about a week later. And he assured me that since I've already met with the accountant, that there's no problem, the money was going to be paid to me. And he also stated that if he had any other jobs coming up.
Let me put my question differently. You rejected the calculation of the accountant and accepted your own. That's correct.
That is very incorrect.
Okay. From that calculation, you did not include the days you told people to sign the attendance register for you.
Like I said initially,
from their calculation, 2 days procured the days you did not attend work, but procured other staff to sign attendance register for you, as if you attended work on that day, contrary to the policy of the defendant.
Every signature on the attendance book was signed by me, and also there is a card for them to reconfirm that I signed in at a particular time and signed out at a particular time. So I did not have to ask anybody to sign for me. I signed everything by myself because I was physically in the office.
Yes.
It was after the third May 2023 that you engaged your solicitor that wrote the SBC, my lord, letter of 9th May 2023, demanding payment for 9 months which you did not work for.
I don't understand what you mean by I did not work for 9 months.
I was after the payment of 3rd May 2023.
Salary for those 9 months. Salary
the solicitor who the defendant will pay you.
Sorry, I didn't get it.
My lord, with all due respect, I should allow witness to talk and respond to questions.
Yes, I'm hearing the witness. What is your answer? What is your answer?
In 6 months, I actually worked, and also in the employment letter, they said both the employer or the employee.
Did you understand the question?
Okay, can he repeat the question?
It was after the defendant's email that you engaged your lawyer to to the demand for payment of 9 months that you did not work for. What is your response?
Yes, I engaged the solicitor to demand for those payments, but I worked for those 9 months.
After the defendant sent you the email?
Yes, sir. Yes, sir. Yes, my lord.
Yes, because I was going to pay. He had been promising he was going to pay. So I was doing it informally, calling him and sending text messages. He kept insisting that he would pay. So when he sent a breakdown that was inaccurate, I had to reach out to a lawyer to help out because I had worked for 8 to 9 months already without getting paid. I had to borrow money. I was in a city that I didn't know anybody. Friends don't stay in.
It's okay. Counsel, go on.
Okay. Your employment with the defendant started when you were a copper. That's correct.
There was like a 1-year break in between. So I was employed as a copper, and a copper employment is not a full-time employment.
Your employment with the defendant started when you were a copper. That's correct.
This is a problem.
What is your answer?
On the other side, I want to answer.
No, I'm saying, did you say problem or your employment?
What is your answer on the question? Your employment with the defendant started when you were a youth copper.
Yes, I worked as a copper for 10 months, and then I was stopped for about a year before I came back, before I was called back as a full-time employee.
Yes.
It was one Mr. Baduru. A former staff of the company, a former staff of the defendant, who is your relative that introduced the defendant.
Counsel, is it part of your plea? The introduction.
No, she denied the knowledge of Badu in her deposition. But we're rounding off. I'm jumping. Yes. One Mr. Baduru, a relation of hers that introduced her to the defendant as a copper. Baduru is a former staff of the company, my lord. That introduced her to the defendant. Witness, that's correct. Are you there, witness, Ms. Pedro?
Yes.
What is your answer to the question?
To what question? I didn't hear it clearly.
I said it was one Mr. Badru, a relation of you, and a former staff of the defendant that introduced you to the defendant, both as a copper and a youth service.
Mr. Badaru is not a relation, so I worked with him during my internship, and I was a diligent staff. So he told the
you worked with it was through Baduru that you knew the defendant. That's correct.
Yes.
What's the answer, please?
Yes.
Okay. You answered yes. Your employment with the defendant was based on humanitarian basis. as a relation of Baduru
No, it wasn't.
and not based on your competence or ability.
No, it wasn't. I studied
That's correct.
Lagos. It wasn't based on humanitarian.
She said no, it
I
wasn't.
studied University of Lagos, and if I wasn't diligent as a copper, why would he have called me back? If I was a terrible staff when I was in my NYC, he would not have called me back.
She said yes, I denied it. She denied it. Miss Pedro, see paragraph 10. Okay. 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 Okay.
Yes.
Okay. See paragraph 10 of
Council,
your
begin to round off.
paragraph 10 of your additional statement on oath. You were under the employment of Zuri, the same time you were employed by the defendant. You were making not regular attendance of work. That's correct.
Under the employment of what?
Zuri, my lord.
Yeah.
During the time she was employed by the defendant, leading to her irregular attendance of work.
Was not a company, or Zuri is not a company. Zuri is a training institute, and they gave a scholarship. So the scholarship was going to take about 2 hours of time every day, which I was doing after work.
Answer the question that she asked. He asked you, are you an employee?
No, I was not. I'm not an employee of Zuri. Zuri is not even a company, so I cannot be an employee of Zuri.
Zuri gave you scholarship. That's correct.
Yes.
You stated so. As a competent and diligent staff of Zuri. That's correct.
Yes, witness. You say
Sorry, I didn't.
they give you, Zuri gave you scholarship. Is it correct?
Yeah. Yes. As a UI designer. As a UI, a product designer.
As UI,
to learn a tech
UI
skill.
designer.
To learn a tech skill.
Yes. Yes, counsel.
You are aware of the penal staff remuneration and compensation policy. You are aware of that?
I'm aware of what?
The defendant's staff remuneration and compensation policy.
Yes.
Yes. That policy, part of it said that failure to attend
Is
work
it an evidence before the court?
Salary.
Is it part of your evidence?
Yes, in our. Okay, might I refer you to Lastly, my lord, I refer her to the document time which she identified earlier. Staff remuneration. Pardon?
But you have withdrawn your documents. Is it the form you tendered or the document, the entire document? If you want to refer her to that document, you have to bring it back. You only stated some pages that you are relevant.
Okay. She said she's aware of the dependent staff remuneration and compensation policy.
Yes.
Okay. In paragraph, under the deduction scenarios, it provided as follows. The employee, the following prescribed deduction will be made in all or any of these scenarios. 1, the employee is absent from work for 1 or more full days for personal reasons other than sickness or disability without approval. For avoidance of doubt, salary is paid for a 30-day month cycle, where an employee is absent on a Friday, it is deemed that the employee is absent for the whole week. I take it again. The employee, if the employee is absent for work for 1 or more days for personal reasons other than sickness, those days will be deducted from the salary of the employee will be deducted. That's correct.
No, that is not correct.
Okay. In the same staff remuneration and compensation policy, which you said you are aware of, paragraph 5.
Council, that staff remuneration and compensation policy, is it in evidence before this court? You can't be cross-examining a witness on document that is not before the court. She admitted, but you have to show her. Or you tender it in your defense and address the court on those issues. Yes, but you can't cross-examine a witness on document that is not before the court.
As court pleases. And finally, witness,
Yes.
I put it to you that you brought this suit in bad faith.
That you brought the suit in bad faith.
From all the stories you have told this court, I put it to you that you brought this suit in bad faith.
That is very false. I'm sorry. I brought the case to court.
Pardon?
Being owed unfairly for 9 months and working
she
without
said that is not correct.
As court pleases. That is all for the witness, sir.
All right.
I brought it to the court because I was being owed for 8-9 months without pay, and I was still coming to the office.
We have noted your answer. We have noted your answer.
I was being diligent with my task.
I'm not asking you. I'm done with you. I'm not asking you further questions. I'm done with you.
Claimant counsel, any re-examination?
No, my lord.
Witness is hereby discharged. Yes. Do you have any other additional witness?
No, my lord. No.
So that's the case for the claimant.
That's the case for the claimant.
All right. claimant's case is hereby closed. Defendants, when will you be ready for your defense? Or you are not entering defense? You want to rest on the claimant's case?
No, sir.
So when are you preparing for your defense?
I don't think, sir.
All right, agree on the date.
And then the defendants are still witness. Travel to Lagos.
I think the Zoom meeting is purposely for the witness only, for the claimant's witness. So we'll continue with our normal case.
As copies.
What did they suggest? Suggest a date for us. No, my clients travel to Lagos this day. We will spend 2 weeks there from there to Abuja for the project we have. So any match will not be permanent. April what? My 14 and 15. It's not permanent. Yeah, 14 and project it says 15 just all of. But for 9th, 10th April, that coming. Okay. What of Easter is 20th April, right? No, the defendant, the witness is currently in Lagos. He traveled just yesterday. What of 16th Wednesday? Yes.
Isn't that too long?
17 is okay, man. 7. About 17 is okay, man.
It's too long.
Like this one, I will tell him ahead of time. After that, with the projects, it will jump to the back on the face. So, okay. I'll stop with this. My Lord, we have agreed to come back on the 17th day of April 2025 for defense. Opening of
My Lord, I was wondering if this is not too long, if this date is not too long. If we have started trial already. The rules of court encourage faster conclusions of trials once you have started trial. Why can't we have a date in March?
Sorry, what are you saying?
Okay, can you pick a date? But I thought 17th April. 17th April. Is it okay? I'm thinking it's too long.
April. It's not coming.
Okay. Let's take the dates. Let's take the date. The 17th of April then. No problem.
Yes, 17th of April.
Judith, is it okay?
Is it okay?
Judith.
It's okay by me.
Okay.
He says it's okay.
I'll stop with this.